Hi, everyone, and thank you to all of you for joining us today. We hope that you all had a great summer. I'm Andy Pushalik, partner in our Toronto office and the National Practice Group leader for the Canadian Labour and Employment Practice, and I'm going to be your moderator for today's session. Today, I'm joined by three of my colleagues. Marie-Noël Massicotte is counsel in our Montreal office. Taylor Holland is an associate in our Edmonton office, and Janice Pereira is an associate in our Toronto office. There is never a shortage of employment law developments, it seems, and this year is no different. Even though we are slowly shifting gears so that we're no longer talking about the pandemic, there are no shortage of issues to keep legal and HR professionals busy at your respective workplaces. So today we were going to focus on three issues that we think are going to be important for many of our clients. First, Marie-Noël will give you the latest on Quebec's French language charter and the implications for employers. Next, Taylor will discuss some trends about increasing damages in Alberta human rights decisions. And finally, Janice will finish off with a discussion about Ontario's new requirement for an electronic monitoring policy. We're going to begin our presentation by talking about what's going on in Quebec with the French language charter and what it means for employers. Marie-Noël?
Hi, everyone, and thank you, Andy, for the introduction. So today I will talk to you about recent amendments that were brought to the French language charter by what we call Bill 96. So Bill 96 introduced several amendments, many of them which will impact employers and strengthen the right of workers to carry out their activities in French. Most of the amendments pertaining to the language of work entered into force on June 1st, 2022, and therefore they already apply. The presentation will remain high level considering the time that we have, and I also wish to outline first that it will not cover more extensive obligations that may apply to employers within the civil administration, and will not cover either obligations that may arise from the Francization process. So we will first start with the job posting. So next, you can go to next slide, please. So when you wish to fill a position, whether it's through hiring, promotion, or transfer, you will need to draft and publish the job posting in French. So what you'll need to do is that if you want to draft it and post it in other language as well, you may do so, but you will need to ensure that the French version is being published at the same time and using the same means of transmission, and that it reaches an audience of a comparable size. So for example, if you are publishing your job posting through the social media in another language than French, you will need to do the same with your French version. Also, it should be noted that later on in the presentation, we will talk about language requirements. So if you want to require the knowledge of a language other than French, so if you are in that situation, the simple reference in a job posting that the position needs bilingualism will no longer be sufficient. You will need to indicate in the job posting the reason that justifies such a requirement. So this is also a new obligation for all employers. Next slide, please. With respect to individual employment contracts, the general principle is that they need to be drafted in French. That being said, you may, with the employee, express the wish that it be otherwise. You will need to distinguish between adhesion contracts of employment and negotiated contracts of employment. With respect to adhesion contracts, so those that are not really negotiated and where the employer really imposes the terms and conditions of the employment, you will first need to present a French version to the employee, who will have the opportunity to examine that French version, and it's only thereafter that a version in another language may be drafted, and then the party may decide to be bound only by the version in the other language. With respect to employment agreements that are negotiated, it's a bit different. You don't need to provide a French version at first. The parties can, from the beginning, decide that they wish the contract to be drafted exclusively in another language. You should also note that if you have employment agreements that were enforced before June 1st, and if they are only in another language, the employee will be in a position to request that it be translated, and such request must be filed before June 1st, 2023. But there's no obligation of translation for fixed-term contracts that end no later than June 1st, 2024. The translation is at the employer's costs, and it has to be done as soon as possible following the request. Next slide, please. The charter also specifically lists some documents that need to be drafted in French. They are application forms, documents related to working conditions, which is pretty broad. It can be a handbook, incentive plan, a commission plan, anything that relates to working condition, as well as training documents. Again, they may be available in another language as well, as long as your French version is available in terms that are at least as favorable as the other version. If you have within your organization such documents that before June 1st, 2022 were available to employees only in another language, you have until June 1st, 2023 to translate them if you want to continue using them. Sorry. Same with respect to group insurance policies. Now the obligation is upon the insurers. They will have to make available a French version of the policy to their client, which in many cases is the employer. And if the policy was already in force before June 1st, they have up until June 1st, 2023 to translate it, unless it expires by June 1st, 2024. Next slide, please. With respect to written communication, prior to Bill 96, written communication addressed to the entire staff had to be in French. Now it's a bit different. So the charter specifies that a written communication addressed to only part of the staff or to a particular employee or a union, all must be drafted in French. This also applies to written communications sent after the termination of employment. However, an employer may communicate in writing with a specific employee if that employee requires it. So for example, if you have an English-speaking employee, he may request that all communications in writing be in English. We recommend that this be documented, as it should be the case also. I didn't mention it before, but with respect to employment contracts, there should be a language clause that puts emphasis on the fact that the parties have decided that it be drafted in another language, or that they'd be bound by the version in another language with respect to adhesion contracts. So it's the same a little bit different, but the same idea with the written communication, that you have documented that it is the employee that has requested the communications in writing in another language than French. Next slide, please. Can you require that an employee has knowledge of another language than French? So the answer to that is yes. It was also the case before, but now there is an additional obligation upon the employer. So it's kind of a two-step test. So you need to demonstrate the necessity of the requirement, so that it's required by the nature of the duties. And you also need to demonstrate having taken all reasonable means to avoid imposing such a requirement. Another distinction from the previous legislation is that it now extends not only to obtaining a position, but also to keeping a position. Next slide, please. So how do you do that? Demonstrate that you have taken all reasonable means to avoid the requirement. So the legislator has established some kind of an analysis that you must conduct, and you need to meet 3 conditions. So the first one is to determine is this requirement really necessary for the tasks to be performed. That's the first step. Second step is you need to look within your current staff if there's anybody else that could take on those tasks. And the third step is that you need to ensure that you restrict the number of positions for which you require another language to a minimum. If you do, this analysis must be conducted before you announce that you will require another language. So if you're posting a position and that you intend to require English, for example, you need to have conducted that analysis before. If you fail to do that, you will be deemed, so not presumed, but deemed to have failed to take all reasonable means to avoid the requirement, and it may open the door to a complaint for a prohibited practice. Next slide, please. So employees are protected against prohibited practices as before, but it's now a bit more extensive. It applies as before to dismissals, layoff, demotion, and transfers, but also now to our employees are protected against retaliation and penalties for various reasons. The main are being exclusively French speaking or lacking sufficient knowledge of another language, demanding the respect of a specific language right, or having participated, for example, in a Francization committee, or having communicated to the Office of the French Language Information. Next slide, please. This is a new protection for employees who are now protected against discrimination and harassment with respect to language. So if they cannot be discriminated against or harassed for having little knowledge or no knowledge of French, or wanting to express themselves in French, and employers have the corollary obligation to take reasonable steps to prevent such discrimination and to make it cease when they become aware of it. If persons or employees who believe that they have been the victim of a prohibited practice or of discrimination and harassment, will have the possibility to file a complaint with the CNASST, which, if unsettled, will be referred to the Administrative Labor Tribunal. For those who are unionized, they will need to file a grievance. Next slide, please. there are new sanctions with respect to non-compliance with the obligation of the charter. So those are mainly, maybe the one with which I should put emphasis is if you have a governmental permit or other authorization, it may be suspended or revoked. And also if you have a contract or a decision that is in violation of the charter and that results damages for the employee, for example, the employee may seek the nullity of the provision or ask for a reduction of his obligations. With respect to the penal provisions, fines have been increased. So just to give you an idea, natural persons are liable to fines between 700 and 7,000, and legal persons from 3,000 to 30,000. There is also a new offense that has been introduced for the disclosure of false or misleading information, or if the employer retaliates against an employee for, in the context of a disclosure or investigation by the office. Beforehand, second offense were, the fines were double. Now for subsequent offense, it's even tripled. And it should also be noted that if you're an officer or director of a legal person and you are, convicted of an offense, the fines for a legal person, not legal, but natural person, are doubled. Also, something new, an offense that continues for more than 1 day constitute a separate offense, which may lead to important fines. Maybe just a quick note on the franchisation process. Now it applies to employers with at least 50 employees, but starting June 1st, 2025, it will apply to employers with at least 25 employees instead of 50. And this, of course, brings additional obligations for employers. So this is a short presentation for a subject that can bring many questions, but this is it for me for today. But if you have questions, please feel free to ask, and we will try to answer that. Thanks.
Great, thanks, Marie-Noël. I think we'll head right over to the next presentation, and Taylor.
Thank you very much, Andy. So my portion of the presentation today will be discussing the trends in increasing damages awards in Alberta human rights decisions. So next slide, please. So before getting into the kind of crux of my presentation, I thought it'd be a good refresher and reminder that while the purpose of my presentation is to talk about increasing damages, that damages are not the only remedy available to complainants through the human rights process. The Human Rights Tribunal has a broad array of remedies that it can award to complainants, many of which are actually non-monetary. With respect to damages, complainants can make a claim for damages for lost income and benefits, and they can also make a claim for general damages for injury to dignity and self-respect. However, the tribunal can also award a number of non-monetary remedies to go along with those damages awards. So I always think that's a good reminder that while we're often thinking about damages, it's not the only remedy available to complainants. Next slide, please. With respect to assessing remedies, including damages, the tribunal will consider a number of factors. The first they'll consider is the nature of the contravention. They will also consider the frequency and intensity of the contravention. They'll consider the vulnerability of the complainant and the impact of the adverse impact on the complainant. With respect to lost wages damages, the tribunal will consider whether a complainant made their mitigation efforts. So any amounts earned by the complainant will be deducted from a claim of lost wages. And often what we find in assessing lost wages is once a complainant has secured alternative employment, the claim for lost wages no longer continues to accrue. Next slide, please. With respect to damages in Alberta, there is no statutory or common law cap, meaning there is no prescribed amount that the Human Rights Tribunal has to ascribe to. So the leading authority in that respect remains Walsh and Mobil Oil Canada. The following principles emerged from Walsh: that human rights legislation must be afforded a broad and purposive interpretation. So in that respect, the tribunal will consider the fundamental purpose of the legislation, which is to recognize all people as equal in dignity and rights. So one of the purposes in assessing damages is to compensate for the complainant for the discrimination that they experienced. So part of their consideration, going back to the factors I discussed previously, is how did the discriminatory conduct impact the complainant, and are we giving them an amount to compensate for that? The second purpose of assessing damages in the Human Rights Tribunal is to prevent further discrimination by ensuring we have awards that are high enough that they deter future conduct from happening and educate service providers and employers as to what is appropriate conduct in the workplace. Finally, the measure of damages requires consideration of the effect of discrimination upon the complainant, and the tribunal will also consider whether the discriminatory conduct was willful or reckless. If the conduct was willful or reckless, that would favor an increase in the damages flowing to the complainant. And finally, inadequate damages awards can have the unintended effect of perpetuating discrimination. So again, the purpose of assessing damages is to ensure that we have awards that are high enough that they deter future conduct and also adequately compensate the complainant for the conduct they experienced. Next slide, please. So the first case I wanted to discuss with you is Yaschuk and Emerson Electric Canada Limited. This was an Alberta human rights hearing resulting from two complaints lodged by a complainant. The first complaint was with respect to gender discrimination in the workplace. The complainant alleged that she was subject to sexual harassment by her direct supervisor and that she was later terminated in a discriminatory manner for reporting that harassment to management of the respondent. That she then filed a second complaint following her first one, alleging that the respondent retaliated against her for filing the first complaint. So by the time this made it through to the tribunal, both complaints were heard together. In response to the complaint, the respondent submitted that the complainant was not an employee within the meaning of the act. In that regard, the individual was subject to an independent contractor agreement. So the respondent alleged that she was not an employee pursuant to human rights legislation because she was actually an independent contractor. It also alleged that her contract for services was terminated prior to her reporting of the harassment to management, so that it was not a factor in her termination whatsoever. And then with respect to the second complaint, the respondent submitted that it conducted a thorough investigation, which found the claims to be unsubstantiated. And it indicated that they did not retaliate against the complainant for the filing of her first complaint. Next slide, please. In terms of findings, the tribunal held that the complainant was an employee for the purposes of the act. Although she was subject to an independent contractor agreement, they found that she was within the context of the act an employee, so it could consider the first complaint. And the tribunal ultimately accepted that the complainant was subject to sexual harassment within the workplace, and that harassment was a factor in the timing and manner of her termination. So she was subject to the protected ground of gender based on the sexual harassment she experienced, and they ultimately found the first complaint was substantiated. However, the tribunal did not accept that she was subject to any retaliation, and it did not make any sort of award with respect to the retaliation allegations. However, because it did find the sexual harassment had occurred and was a factor in the termination, the tribunal then was tasked with considering what the appropriate damages award would be. Next slide, please. The director and complainant made separate submissions with respect to damages. Sometimes what we'll see is that the complainant will adopt the damages requested by the director's counsel. In this case, they made separate damages submissions. However, they did seek the same types of damages. So they sought general damages, damages for lost and future income, and special damages. The damages for future income and special damages were not awarded by the tribunal. They dismissed those requests. However, the tribunal did award a fairly significant lost wages award in the amount of $42,750. It also made a general damages award in the amount of $50,000, along with an award of prejudgment interest on both of those. So something to keep in mind with respect to prejudgment interest is that general damages prejudgment interest is calculated differently than prejudgment interest on the amount of lost wages. There is a higher amount tied to prejudgment interest on a general damages award than a loss of income award. So that's just always something to keep in mind, that when we're talking about the increase in these damages awards, it's increasing the damages, but it's also increasing the amounts of interest that accrues on that damages award. And for those that are attending today that have any experience being in front of the Human Rights Tribunal, it takes many years to get there. So the damages awarded can have a significant effect on the interest that accrues over a period of years. And with respect to the damages award, the following was kind of the rationale for awarding the $50,000. Firstly, the discriminatory conduct had a profound effect on the complainant, causing her significant mental health issues, which prevented her from gaining meaningful employment. That likely also ties into the reason that the lost wages were so high, because her mental health was exacerbated to the point where she was unable to seek employment for a period of time. Secondly, the employer's investigation was flawed by failing to interview witnesses identified by the complainant, and it also failed to preserve relevant emails between the complainant and the alleged offender. Thirdly, the sexually harassing conduct was serious. Fourth, the employer's attitude in responding to her complaints were dismissive and cavalier. And finally, the tribunal found that the termination was done hastily, and that likely ties into kind of the flawed investigation that took place. Next slide, please. Second case I want to discuss with you is Fisher and Devilbryn Property Services, Inc. This was an Alberta Human Rights Tribunal hearing of a complaint of discrimination on the grounds of family status, marital status, and mental disability. In this case, the complainant was employed in an administrative role. Her role wasn't actually really well defined, so they didn't really have a position description or anything, but the tribunal did accept that she was in an administrative role for a period of approximately 3 years. At the time, she was married to the director of operations of the respondent, who ultimately resigned his position in April of 2017. Following her husband's resignation, the complainant was advised that she could no longer continue her administrative role due to what the respondent deemed to be a conflict of interest. However, they told her that she could remain employed if she would go work in the field. After being told this, the complainant requested a period of 2 business days to discuss her options. And during that time, she was ultimately placed on a 2-week medical leave at the recommendation of her doctor for anxiety and stress. And then ultimately what happened is the respondent subsequently terminated the complainant with just cause shortly thereafter. Next slide, please. So the tribunal noted that to the extent the complainant's relationship would be a factor in her termination, that would engage the grounds of family and marital status. That was just to state that whether or not the protected characteristic would be engaged, not necessarily a finding at that time, but they did note to the extent that a person's relationship status has an effect on their workplace and they receive an adverse impact in relation to that relationship status, then they will be engaged under the Act. So the tribunal did accept that the complainant had a mental disability based on her doctor's diagnosis of anxiety and stress. The respondent had alleged that the complainant wasn't suffering from a mental disability because she, quote, did not appear sick. The tribunal did not take kindly to that, and I'll get into that when I'm discussing the damages. However, the tribunal did accept that the mental disability was engaged because she did have a doctor's note saying that she was subject to anxiety and stress, and they considered that to be a mental disability within the purview of the Act. So ultimately, in assessing whether or not discrimination occurred, the tribunal did find that the complainant's relationship was a factor in her termination. The respondent essentially argued that since it could no longer trust her husband, it could also no longer trust her. So they found that the respondent's suggestion indicated that her relationship status did affect her termination. The tribunal also found that the respondent submitted what it called extremely underwhelming evidence to support its just cause position. And the tribunal actually indicated that the underwhelming evidence suggested that the respondent's rationale for its what it called its non-discriminatory conduct was dishonest and in bad faith. And I think that's important when we get to the damages on the next slide. Next slide, please. So in this case, the tribunal awarded the plaintiff lost wages in a fairly nominal amount. I think she was able to find work pretty quickly after she was terminated. However, it did award general damages in the amount of $30,000. And again, there was then prejudgment interest on both the lost wages and the general damages. With respect to general damages, the award was based on the following factors. Firstly, it was not uncommon for the tribunal to award general damages in the range of $20,000 to $25,000, but the tribunal wanted to make it clear that in no way is $25,000 considered a ceiling. It's just simply average awards. Secondly, the respondent engaged in multiple acts of discrimination because it discriminated against her on the basis of marital status, family status, and mental disability. Thirdly, the respondent alleged that the complainant was lying about her need for accommodation because she didn't appear sick. And the tribunal considered this to be really poor conduct, and it thought it required denunciation and a deterring effect. So again, that goes back to the kind of first principles I discussed earlier in the presentation, that we're not only looking to compensate plaintiffs for the conduct they experience, we're looking to also deter this conduct from happening in future situations. So when assessing damages, the tribunal will consider whether the award has a deterring effect. The respondent's conclusion that the complainant's marital status made her guilty of her spouse's actions was considered dehumanizing by the tribunal. The tribunal noted that we're all supposed to be seen as equal individuals and our actions are our own. So the respondent's assertion that any action on behalf of her husband could also be attributed to her, they thought was dehumanizing, and infantilizing is actually the language they used as well. And then finally, in assessing the award, the adverse impact was termination. So they considered that to be a serious adverse impact. And one final thing in noting about this case is there was actually a subsequent costs award where $5,000 in costs were awarded against the respondent. And this was in relation to it submitting what the tribunal considered irrelevant records that were of a personal and intimate nature of the complainant. These records came into the possession of the respondent through no fault of the complainant. And the tribunal just essentially considered these records were provided for the purpose of embarrassing the plaintiff the complainant, and they considered there to be no relevant purpose to them. So they awarded costs against the respondent. And costs are extremely rare to be awarded in the human rights realm. So it's usually rewarded against a party for engaging in some sort of misconduct, similar to in a court claim where we can get enhanced costs for litigation misconduct. Costs are usually awarded as a deterring effect in the human rights realm. So with those two cases in mind, the Yaschuk decision is currently the highest general damages award in Alberta, being $50,000. But as I alluded to earlier in the presentation, there is no statutory or common law cap. So it's not to say that that's necessarily a cap. We can and probably likely will see future awards that are in excess of that $50,000. And I thank you for listening to my portion of the presentation. I'll turn it back to Andy.
Great, thanks, Taylor. And moving right along, we will finish up the formal part of the presentation with Janice, who will talk to us about the new electronic monitoring policy that's required for Ontario employers on October 11th.
Thanks, Andy, and hello, everyone. Good afternoon or good morning, depending on where you are. Thank you so much for joining us today. Next slide, please. So as Andy had mentioned earlier, in April of this year, Ontario's Employment Standards Act was amended to include a requirement for provincially regulated employers with 25 or more employees in Ontario to implement a written electronic monitoring policy, or an EM policy for short. For this year, employers with 25 plus employees in Ontario as of June 1st would need to implement their EM policy by October 11th, which, believe it or not, is just over 2 weeks from today. For any following year, employers with 25 or more employees in Ontario as of January 1st of that year would need to have an EM policy in place by March 1st of the same year. Now, the Act doesn't really define electronic monitoring. There is, however, an interpretive guide that the province has released, which states verbatim, electronic monitoring includes all forms of employee monitoring that is done electronically. Now, I chuckled when I first read this because it's, a pretty circular definition. It doesn't really provide us with a whole lot of guidance, and it can be interpreted very expansively. So some examples of electronic monitoring could include, for instance, tracking employees' locations through devices such as GPS or through cell phone applications that have location services enabled. Electronic monitoring could also include technologies used on corporate networks and devices, such as laptops, computers, or cell phones provided by employers to employees. Now, we've seen many things crop up in our clients' policies, and the most usual ones tend to be tracking of websites visited during work hours, how long an employee might spend on a certain website, keystroke logging, or even monitoring of key fob usage or premise access cards to track when employees leave and enter the office. Now, these are some fairly typical examples, but some more creative examples of monitoring may also include electronic sensors that track how quickly a cashier at your local grocery store scans items at a checkout. So on the next slide, we can take a look at what such electronic monitoring policies need to include. So an employer's written EM policy will need to include information regarding whether the employer electronically monitors its employees. And if it does do so, there needs to be a description of how such monitoring is performed and under what circumstances. Finally, the EM policy will also need to include the employer's purpose for collecting information through such electronic monitoring processes. So for example, while employers might have policies that prevent employees who are working remotely from doing so outside of Canada, as this could have tax implications for employers, they might track the location of an employee's remote working connection to an internal online server belonging to the employer. The employer would need to disclose this in their EM policy, along with a statement that such information is tracked in order to ensure that employees do not work from outside of the country. So this is just a small example of what an EM policy and its contents might look like. Now, of course, such policies need to be tailored to reflect the realities and nuances of each employer's business practices. So we don't expect that any two policies would look, exactly alike. Employers will be required to provide a copy of their EM policy to each employee within 30 days of introducing it, or within 30 days of any amendments to the EM policy. It's also important to note that policies need to be dated with any amendment dates tracked as well, which is a strict requirement under the ESA. Next slide, please. Another important thing for employers to be mindful of when drafting their EM policies is that in addition to capturing electronic monitoring that is conducted on employer-issued devices, the policy must also disclose monitoring that may be undertaken while an employee uses their personal devices for work-related purposes. So, for example, employees may choose to access or check their work email account using their personal cell phone while at home and outside of work hours. If the employer can collect and monitor information, such as when that employee logs into their work email and the emails that they send and receive, even while using a personal device outside of their standard work hours, this would certainly need to be captured by the EM policy. Now, the interesting thing is that at present, complaints to the Ministry of Labor can only be made and investigated when there is an alleged contravention of the employer's obligation to provide its employees with a copy of the written policy within the required timeframes. That being said, the Ontario government has stated in various press releases that the objective of the new amendments is to foster more transparency between employers and employees, especially in light of the fact that a lot of employees are now working from home or working with a hybrid plan in place. Now, in light of the stated objective, employers should take an expansive approach when considering what types of information to include in their EM policies. Next slide, please. Now, I did want to discuss a few tips and tricks for employers when drafting their policies. One of the most important things to note, especially if you're a larger organization, is that management might not be aware of the types of electronic monitoring that the company can actually perform, especially if a lot of the tech side of things is handled administratively by a company's IT department rather than by management. So, for example, management might not be aware that there are certain software solutions, tools, applications installed on company devices that can collect electronic usage information by automated means. So, for example, a web browser application on an employer-issued device might be programmed to automatically create logs of the websites visited by employees in order to detect cybersecurity threats, and then send automated alerts to the IT department, even though management may not be aware of this or involved with this process in any way. Employers could then access these logs for other purposes, including to, for example, monitor employee productivity during work hours, which would fall within the scope of electronic monitoring for the purposes of the Employment Standards Act. We would therefore encourage employers to work, very closely with their IT departments when drafting their EM policies to ensure that the policies are as comprehensive as possible and align with the government's stated objective of transparency. We would also encourage employers to distinguish within their policies to the extent possible when information regarding an employee's activities is collected by passive or automated means, and when the employer may choose to conduct more targeted or intentional monitoring. So, for example, an employer might only choose to review an employee's internet browsing log when the employer is concerned that the employee is spending too much time online shopping or even gaming during work hours. And if this is the case, this should be spelled out in the EM policy itself. Another tip is that while employers are really encouraged to be transparent about the electronic monitoring that they undertake, they shouldn't give away so much information that employees can then circumvent any security measures that are put into place. So a good example of this is an employer who is concerned about data being leaked to a competitor might have a software that alerts management whenever an employee uses their work email to send an email to a competitor's email address. And in such a circumstance, the employer should disclose in its EM policy that emails sent from work email accounts are monitored to ensure the protection of the company's confidential or proprietary information. The employer should not, however, disclose in its policy that the software specifically targets emails sent to addresses that include a competitor's name. Otherwise, employers who learn about this and who want to leak data to a competitor might wisen up and send the data to a personal email address in order to go undetected by management. I will end on that note again with a reminder that affected employers are required to implement their policies by October 11th of this year. For those who are only, just now turning their minds to this requirement, and as Andy mentioned earlier, Dentons has a template electronic monitoring policy and FAQ sheet, which clients can purchase today for a fixed fee. So please don't be shy to reach out if you are interested. And with that, Andy, I will hand over the proverbial mic back to you.
I will now take the proverbial mic. So thanks, Janice, and thanks to all of our speakers. And we do have a bit of time for questions. So Marie-Noël, I'm going to start with you because there is a lot of interest in the new French language law. So the one question is the legislation, when it references number of employees, is that a reference to the number of employees in Quebec, or is that Canada-wide?
Okay, so, well, the same issue was there before with respect to or currently with respect to the 50 employees. There is not a lot of case law with respect to the French language charter, and there is no definition within the legislation, within the charter, of what is an enterprise or a business. But that being said, I would be of the position that we could certainly argue that it refers to the number of employees you have here in Quebec. But you know, it could still be open for discussion. I could undertake to try to see if this has been tried before, but I don't think so. But I can verify and give you a further answer if I find something specifically on that point. But again, there's no definition of what a business is within the charter, but from my opinion, I would certainly argue that it needs to be 25 within the province.
Great, thanks, Marie-Noël. Taylor, the news about the Alberta human rights damages, that's not even something that I had been following. You referenced the one case with the $50,000. Do you think that we're at the high water mark, or in terms of the facts were so egregious, or is there some other fact pattern out there that could actually lead to an even worse result for an employer?
Yeah, that's a great question. I think it goes back to the principles that I discussed in my presentation, in that there is no statutory or common law cap. So I don't think we can consider any award that comes out of the Human Rights Tribunal to be the high watermark or a benchmark by any means. I have heard some rumblings that the Alberta Human Rights Tribunal may be looking to make their awards more in line with what's happening in British Columbia and Ontario, which do have awards in excess of $50,000. For example, there's a case out of British Columbia that I'm aware of where general damages in the amount of $176,000 were awarded for really serious and ongoing racial discrimination. I don't necessarily think we'll get that high in Alberta, but it's always a possibility. But I think with the right facts, particularly if it's serious misconduct that's ongoing, many acts of discrimination, and is willful by an employer, then I think we would probably see an award in excess of $50,000.
And that would be certainly, so thanks, Taylor. That would certainly be in line with Ontario's experience. I think people are aware that a couple of years ago, there was a damage award in excess of $200,000. And you made the good point about beyond just the damages, you also have to be careful about lost wages and interest. That can really catch up. So the electronic monitoring policy, Janice, we've had a lot of questions about this, a lot of questions about the fact that there is no definition about what is electronic monitoring. What do you see as kind of the thing that's probably going to be the most tricky as employers work towards implementing this policy for October 11?
Right. Yeah, that's a great question. And I think there's, really two parts to that. So I would say that the first part is just knowing what to include in a policy. We've had a lot of clients approach us saying, we do a lot of passive collecting of information by automated processes that nobody in management ever looks at. Do we then include that information in the policy? Or are we really to be concerned with just the information that a human from management actually looks at and considers and monitors to determine whether or not it breaches a company rule or a company policy? And so I think that's where the issue of not having a clear definition of what monitoring entails becomes a problem. But as I said, because the government's stated intention is transparency, we have been urging clients to be as expansive in their approach as possible and consulting with their IT team to know what exactly they're capable of monitoring when it comes to employee activity. And the second part that I think will be really tough is being able to, be transparent in disclosing to employees the types of activities or computer usage that's being monitored. But at the same time, being able to reassure your employees that, hey, the company's not trying to spy on you. These are normal business processes that most companies use or undertake. And, the whole practice is not geared towards spying on employees without a legitimate business reason for monitoring their activities. So I think once employer side clients are able to get those two pieces pinned down, it'll be a lot easier of a process when it comes to October 11th.
Great, thanks, Janice. Marie-Noël, coming back to you, a question that's come in, does this mean if you communicate spoken/written in French and the response comes back in English or vice versa, you cannot make a firm request to keep the communication in one single language?
Well, first of all, spoken and written communication need to be distinguished. So what applies to all employers is that the basic principle is that the written communication need to be in French, unless the employee requires it. So if you send a communication in French, for example, and the employee answers to it in English, then you could ask the employee if he'd like further written communication to be in English only, and then you can decide that, you know, the written communication will from now on strictly be in English with that specific employee, for example. And I would document that if I were the employer. However, as an employer, you cannot impose the English you cannot impose the English language or any other language than French in your written communication with your employees. So, but of course, if the employee responds in English, I think that you should have the discussion as to whether he prefers written communications to be in English or in French or in another language. With respect to oral communications, the situation is a little bit different. This will be addressed through the Francization process. So the goal of the Francization process, if you are a business that is subjected to that, is to have the use of French generalized throughout the business. So regardless if it's, here we are talking about employment issues, but it's going to go further than that. But with respect to employment issues, if you are the subject of the Francization process, you will need to ensure that all internal communication, regardless if they are oral or in writing, are usually in French, and also that your tools are in French, and that the management has sufficient knowledge of French and things like that. But it's something that needs to be worked out with the office of the French language. So it doesn't necessarily mean that from day one, everyone needs to speak French within the business. It's like a goal to reach the generalization of French within the business. It doesn't necessarily mean that everything that is oral will necessarily need to be in French all the time, but the goal to be reached is that at one point, use of French will be generalized within the business, including in your oral communications. So I don't know if it's an answer that gives you enough to work with, but basically what applies to all employers and that will be, mostly implemented will be the French in written communications.
No, that's great, Marie-Noël. And we're going to see if we can sneak two last questions in here. Taylor, just interested to know what your experience, or if you have any anecdotal experience about how fast human rights matters are proceeding in Alberta. Certainly in Ontario, it's a fairly significant delay, and wondering if the experience is the same in your province.
Yeah, it's definitely similar in our province. Matters stay in the queue for quite a while here. It's usually a period of years, and there isn't. What would happen in a court case is there sometimes is summary processes where someone could file, say, for example, a summary judgment or summary trial process. That doesn't happen at the tribunal. So by the time it gets to the tribunal, it's usually been in the queue for a period of years. And unless it's summarily dismissed before it gets to the tribunal, you're usually waiting a period of probably another year and a bit by the time it reaches the tribunal stage before you're actually in the hearing. So if we are talking about a full length case that goes all the way to a hearing, it's usually the period of years, which my understanding is consistent with other provinces.
Great. So final question is going to go to Janice. And one thing we've been hearing from our clients a lot is, can they just simply combine the electronic monitoring policy with something that they may already have in existence. So whether it's an existing privacy policy or an existing computer policy.
Yeah, that's a great question, Andy. And as you mentioned, quite a common one. I think a lot of our clients, especially in Ontario, have been experiencing policy fatigue, where they don't want to have, yet another policy in their handbook. And understandably so, as especially over the past year, Ontario has been very policy heavy. So that being said, clients can implement the EM policy requirements into an existing policy, such as a computer use policy or a privacy policy. But that being said, as I mentioned earlier, a complaint regarding the electronic monitoring requirements can only be made to the ministry if the employer hasn't satisfied their obligation to deliver a copy of the policy to employees. So to avoid this, if employers want to include the EM policy in an existing policy, they should make it very, very clear that that is in fact the EM policy. So this can be done, by example, for including subheadings, that's a electronic monitoring policy, including a scope of what electronic monitoring entails. We would also recommend, circulating an email to employees within 30 days of October 11 to advise them that this new policy has now been implemented as part of a computer use policy, for example, and where it can be found. And that could avoid a situation in which an employee incorrectly believes that they just haven't received a copy of the policy in accordance with the ESA timelines.
Great. Thanks, Janice. And thanks to everyone for joining. As we get to the end of our hour together, we hope that you found the session valuable. As a reminder, the electronic monitoring policy template and FAQ document is available for the fixed fee of $1,000. So there's going to be a way that you can just click right through and purchase it. Otherwise, just reach out to the Dentons lawyer that you ordinarily are working with. We still are offering our disconnect from work policy template that was required back in the summer. So if you do need that as well and you need to take that off of your plate, by all means, let us know. We're back on Friday, October 28th, so look for an invitation on that. There's going to be a lot of talk, I expect, over the next little while, as there has been already, about the economic uncertainty. And so we're going to try and be providing a bit of a primer on layoffs and things like that, that may be some difficult decisions that employers are going to be making as we head further into the fall. Thanks again to everyone for attending. Thanks to our presenters, and have a great weekend, everyone.